airport only to have your phone taken away, your laptop searched, and your social media scrutinized. Hi everyone, welcome to Immigration Talk Show. I'm Rajni Bharara, your host, and before I move ahead, let me read out this very important disclaimer. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. All right, after this very important disclaimer, welcome back everyone to another episode where we dive deep into the realities of CBP electronic device searches and what every visa holder, whether on H-1B, F-1, or L-1, must know before traveling. To break it all down, we have Jonathan Wasden from Wasden Law, an expert in immigration law, and he's here to guide us through the legal strategies to protect your rights. So, without any further ado, let's welcome John on Immigration Talk Show once again. Welcome back, John, to Immigration Talk Show.
Hey, thanks for having me back.
It's always a pleasure having you, John. Thank you again for being here. John, I would like to ask you this question that why all of a sudden, everything is happening all of a sudden. So why have these searches started happening, out of the blue?
So I think for a while, CBP has become progressively more aggressive at the port of entry. I will say that the moment Trump came into office, things got incredibly more aggressive and more abusive. And no one is particularly safe. I had a U.S. citizen client who was a naturalized U.S. citizen that was coming home from international travel and was stopped at CBP, taken into secondary, and grilled for 4 hours. He's a U.S. citizen. There's really nothing they can do to him. They have to let him in. But they were just grilling him and questioning him about the details of his businesses. He had multiple businesses, and asking, why do you have 3 businesses? The irony of that is, Trump's best buddy, Elon Musk, has multiple businesses as well and is also a naturalized U.S. citizen, but he's white. And so we see that CBP is really going after anybody, who is not fitting their criteria of who they want in America, pretty much. And so it is important for everybody to realize that they have to be extra careful and take extra precautions when dealing with this rogue agency, because they are truly out of control. And you have to think about what is best for you and understand what their motives are and what their tactics are to protect yourself.
Okay, so, do you mean are they going after people of color?
Yeah, that seems to be the consistent trend. Trump has a very clear image of who he wants in America. If you look at his DEI, anti-DEI initiatives, he's directed, the Pentagon to go through and eliminate any reference to people of color. They even went through and took Colin Powell's photos down from the Pentagon, and Colin Powell was a chairman of the Joint Chiefs of Staff, a highly decorated general, and a Secretary of State. But they took it down because he was Black. And so that's kind of the attitude that's going through the U.S. government at the moment at the highest levels. And I think that carries through down to the port of entry.
Wow. Okay. But John, like CBP officers, they have significant authority at US ports of entry. And this includes, of course, searching of electronic devices. But then many visa holders are unaware of the limits of these searches, right? So I would also like to understand, and I would also like to know from you that what legal authority does CBP have to search electronic devices of, H-1B, F-1, or any other visa holder at the US border?
Yeah, so when you're coming through the port of entry, they can search anything. It's one of these areas where your constitutional right and protection to searches and seizures is at its minimum, if it even exists. So they can't search anything. Now, you don't have to give them your passwords to your devices, but if you don't, then that might impact your admission. If you're a U.S. citizen and a green card holder, they shouldn't really have any ability to keep you out of the country, even if you refuse. But we've been seeing crazy things happen with green card holders of late as well. And so, just be aware that they have the right to search They have technology that they can plug your phone in and crack codes and get into your devices. And so the question that I always ask people is, do you want to make yourself vulnerable by carrying your devices with you? And, if you give them your devices, you have no control over how they use the information that they find, what crazy interpretations of information they make, and what conclusions they make. And what's problematic about that is you can't challenge their decision. You can have somebody making outlandish, accusations against you at the port of entry, and there's nothing you can do to challenge that. And so it's a matter of how much do you trust CBP to make common sense, correct decisions versus how much, do you want to protect yourself?
Okay, right. So before I ask my another question, John, I would like to say hello to Rag. He says, hello, Rajni and John. Hi, Rag. Please continue posting your questions. We are here for a while and we'll be more than happy to take all of them. So make sure whatever question that you have for John, keep on commenting. And Sunita is also here. Hi, Sunita. And guys, we are live on YouTube, LinkedIn, and X. Make sure you subscribe to us, follow us, and also if you have any question, so post them in the comments below on LinkedIn, X, and also on YouTube. And I also on Facebook too. So make sure that you are live in all those platforms. And John, with this, I would also like to understand, and I would also like to know from you that do you think that CBP searches, especially with the electronic devices searches that is going on, do you think this is like somewhere it is happening because of the governmental overreach?
So I think there's a couple of things going on. I think for a long time, DHS, who is the parent agency of CBP and USCIS, has had a strong bias against especially the Indian IT staffing companies. And so they've pointed a lot of scrutiny and a lot of effort towards monitoring those people. So I think if you're working for an IT company, an IT staffing company, and or you're Indian, your level of scrutiny at CBP is going to be much higher than just about anybody else's. The types of things that we see them doing at the border, especially with the H-1B community, is we see them going through their electronics, sent emails, received emails, trashed emails, your Word docs, photos, deleted photos, messaging apps, bank apps. And just this is a small sample of ways they misuse that evidence. So the most common one they're going for is looking for resumes. And they look for resumes and they've found resumes that people have received from others. Now, the first resumes I did in my professional career, I asked people for their resumes so I could use it as a template and come up with my own. And people that have done that and they've got these resumes in their email inboxes, CBP officers have gone through and said, oh, you're committing fraud by using somebody else's resume. Now, that's a wild accusation that's completely unsupported by reality or the law, but that's the conclusion CBP makes, and that's what they use to remove somebody from the US and put a 5-year bar on them. A fraud finding requires that you make a false statement to the US government in support of an immigration application or benefit. And if it's in your email inbox, you've never given it to anybody, you've never given it to an employer, let alone the US government, it doesn't qualify as a fraud finding. But again, you can't challenge anything that CBP does. The other thing we see is just going through bank statements on your banking apps and looking for transactions and questioning about transactions and claiming that somehow that you're involved in illegal commerce. And then your messaging apps looking for prior employers, and engagements you've had with prior employers. One area that is just really crazy to me that they delve into is for people that are on working with a staffing company, they'll ask about your pay. Now, your rate of pay as an H-1B is on your LCA. It doesn't matter how much your company is getting. It doesn't matter what percentage of the contract your employer gets, your rate of pay is on the LCA. And so they have been questioning H-1B holders about the percentage of pay the employer gets out of the overall contract. And if the employer is getting a percentage that CBP and all of its wisdom determines is too high, they will label you with a fraud finding somehow and remove you because of that. So these are the types of things that CBP is scrutinizing and looking for evidence and information in your electronics for. And it's for all of those reasons that I tell people, don't carry your electronics to the port of entry, because the moment you carry those with you, they're subject to search. I would say that you're much safer having a trusted friend or associate FedEx those, overnight those to you once you are admitted. Because if you don't have them on you, there's nothing they can search. And that's a much safer approach to go.
But then, John, what about invasion of privacy? Because everyone, I mean, they have the right to privacy, right? So, and especially at around this time, people live on their phone, their every information, and also their tickets, and every receipt, and also their IDs. Everything is on phone. Then
Mhm.
how can one not carry phone? I mean, this sounds weird, right? And also bizarre.
It is a bit going back to the 1990s. Paper tickets, physical, documents. Alternatively, you can get a burner phone, but if you get a burner phone, do not use your regular Apple ID or Google ID. Don't download any of the apps you would normally use for messaging. Don't load your email apps, your banking apps, nothing. Just strip down so you've got your contact information. If you need an airline app on there for your boarding passes, that's fine. But I would just make it as streamlined as possible with no connection to your regular electronics whatsoever, so that there's no way for them to abuse and misuse the evidence that's on your phone.
Okay. All right. Thank you so much for answering the question, John. We have a lot of viewers watching us, and they have also posted their questions. Ansa is here, and of course, Raj has already posted his question. So, Ansa, we are definitely going to take your question, but in a bit. Please wait for some time and let me, finish few of my questions, and then we are going to move into your questions. Okay. So, John, let me also talk about, the secondary inspections that is happening. Um, uh, So
Mhm.
now I would like to understand, I mean, getting sent to secondary inspection can be, of course, it can be nerve-wracking, right? And especially for visa holders who don't know what to expect. So if you can please help our audiences understand what should visa holders expect during CBP secondary inspection process, and how should they prepare themselves for that?
Yeah. So if you're getting put into secondary, there is some type of flag on your record, right? And that flag could just be that you're working for a staffing company, or that you've worked for a staffing company in the past that USCIS has flagged, or you have any kind of relationship to a company that's been flagged in the past. Their whole goal when you go to secondary is to find reasons to support their decision to remove you from the country. That's their entire goal in secondary. Now, they use techniques, interrogation techniques that are used to interrogate POWs, criminals, and the lot. And it's a combination of things. They try and build rapport, build this relationship of trust with you, and make you feel like they're there to help you and they're going to do you a solid and they're going to help you out. And then they try and lull you into that sense. And if you're not completely lulled into that and give them what they want to hear, then they switch with the threats. And everything is about making you, or trying to make you, give them back what they are telling you. They'll give you a narrative, they'll give you a story, and they want you to agree to exactly what's in that story, and then have you sign a document confessing to that. And they'll make you think that if you do that, good things will happen to you. And so people get, basically tricked into signing a false statement because the CBP officer has promised them that everything will work out and everything will be okay if they just sign this statement. Nothing could be farther from the truth. On the flip side, when they get to the threatening stage, they will threaten that they'll put you in jail and you'll go to prison. Absolutely not true. 100% not true. They can't do that. the best that they can do if you're coming through the port of entry is remove you and send you on your way. So don't believe them when they say that. I've also heard reports of people going through CBP where they've threatened to take away their children. They can't do that. And all of these threats that they have that are calculated to terrify you, they can't do. The worst thing they can do is hold you for a day or two and then send you home. And it's important for people to know that. Yeah, and if you agree with them and you sign the statement that they've prepared for you, then you, in all likelihood, have just ended any hope or any future you have of living in the US again. Because embedded within those statements that they prepare for you to sign is inevitably an admission that you have committed fraud or misrepresentation. The one thing I would caution everybody is when you start the interrogation, when they start the interrogation, don't sign anything up front. Don't sign an electronic signature pad. Don't sign anything and refuse to sign anything until you have seen an actual copy of whatever it is your signature is going to be placed on. If they have prepared a statement, you read through that, you make your edits, and you agree to what is true, and you refuse to sign something that is false. Typically what they'll do is it'll be a question and answer. And they'll put in their question, you know, when you knew that this was a fraudulent company, when did you know this was a fraudulent company? And that they'll put something like that that's just really explicit and uses the word fraud. And then they'll type your answer. And the answer that they type may or may not be the actual answer that you gave. So if they're using that loaded language, the language that they're going to use for a fraud finding that bars you from the US forever, be very cautious about that and read that statement carefully and refuse to sign anything that isn't correct. And if they're using that type of language, you don't have to sign it. You don't have to let them have that be the record, the official record of what happened in the interrogation.
But John, do the travelers or the visa holders, like, do they have a choice of, saying no to the secondary inspection, or is it mandatory?
So they can request withdrawal of their application for admission.
Okay.
And what that means is you take your application back and you go back home. If you withdraw your application for admission, you don't incur the 5-year bar if it's approved. Now, CBP has discretion whether or not they're going to approve that withdrawal or if they're going to remove you. So, but once you present the border and you make your application for admission to the US, your rights and your opportunities become very narrow very quickly.
Okay. And also some travelers feel that CBP secondary inspections are arbitrary, right? Targeting, certain visa holders unfairly. So, like, is it right, or do you think,
No,
they're
I
not
think
targeting people unfairly?
no, I definitely think the people are correct when they suspect that it's being targeted unfairly. The trouble we have when we're dealing with CBP is that it's one of 3 areas in the immigration law that courts are largely incapable of doing anything for. The courts are not allowed to review a removal order at the port of entry. They're not allowed to review a consular decision, denying a visa, and they're not allowed to review the denial of a application for adjustment of status on a 485. Those 3 areas are pretty bulletproof on individual decisions. Now, if there's enough information coming from enough different people showing that the government is engaged in what's called a pattern or practice of violations of the law, then you can sue to change policy, to change what USCIS does in their operations or what CBP does in their operations. But those pattern or practice cases take a lot of evidence and a lot of information, and they're not geared at giving relief to an individual. It's geared at changing the law going forward. And so they're very difficult things to pursue. They're difficult cases to prepare and to win. And so they take years. So if you're going through this process, the quicker option is to take steps to prepare yourself and protect yourself and don't count on the courts coming to your rescue.
Okay, okay. And also, I would like to understand that do CBP officers have discretionary power to decide who undergoes a secondary inspection, or are there some set of rules?
So typically, if there's anything in the system that flags you, then you'll go to secondary. If on primary inspection, if there's something that makes the inspectors question what's going on or doubt the validity of your documents, or if you're acting suspicious, they'll refer you to secondary. But usually the decision to put you into secondary has been made before you ever get to the port of entry.
Oh, okay. Wow. All right. So I see a lot of questions here. Before I move ahead, John, let me take this very interesting and important question that I see. It's related to something that we are talking about. So Chandan Reddy is here and he says, "Hi, can CBP deport even if we have signed G28 without communication to attorney?" What do you have to say?
So your rights to counsel at the port of entry are kind of tiered. If you're being detained or suspected of a crime, you have the right to an attorney. So you always want to ask them that question. Are you detaining me? Are you suspecting me of a crime? If they start throwing out, immigration fraud, then technically that's a crime under the US code. And so you could say, you're suspecting me of a crime because you're talking about fraud. I have a right to an attorney and I want to talk to my attorney. Now, on just regular immigration things, you can request to talk to your attorney or have your attorney talk to CBP, but CBP won't talk to anybody and won't allow you to talk to an attorney unless you have a form G28 filled out, signed by you and the attorney before you hit the port of entry. And you really need to be carrying it with you. So the only way that you're going to have access to an attorney at the lower level type interactions with CBP is that G28. Now, the G28 just allows the attorney to speak with them. It doesn't guarantee that CBP will allow the attorney to talk with the officers. So but it's the only hope you've got of having an attorney kind of intercede for you. And like I say, before you travel, you need to have that G28 signed and executed. And you need to talk with an attorney about how to handle the inspection process at the border.
Okay, and now, if the attorneys are trying to save someone who the administration is trying to deport, then the attorney also, I mean, they're also coming under radar, right? Right, John?
Yeah, the Trump administration has said that DHS and DOJ both should be looking for ways to hurt immigration attorneys, basically, and get their law licenses taken away from them. So in the federal court system where I typically practice, there's a thing called Rule 11 that allows a court to penalize attorneys for frivolous or vexatious litigation, or just making a claim that is so outlandish it could never win in court. And what Trump has said is that basically any challenge to his immigration policies is going to be Rule 11 material. So immigration attorneys that are in my line of work are just expecting that we're going to have to deal with a lot of ancillary side litigation on Rule 11 things because the administration is very vindictive and is just trying to silence any type of opposition that they're facing in the immigration space.
So are they targeting only the attorneys who are maybe taking asylum cases, or are they going after all of them?
No, the language of the executive order is pretty broad. It's anybody that challenges the administration's priorities or their agenda. So asylum's obviously a hot button issue for them, but so is the H-1B. And they're going after just about every element of immigration right now. So I don't think they're going to limit it to any one particular area.
Wow. I think now soon we should also do another show, targeting, for immigration attorneys, right? What rights do they have against the administration, right,
Yeah.
John?
Yeah, it'll be interesting to see how it plays out. The really interesting thing to me is how the courts will receive these frivolous Rule 11 allegations. because it's very clearly a direct attack on attorneys and people's access to the courts and access to lawyers, and it's an intimidation attack. And so I would hope that courts would have a little bit more respect for the process and wouldn't have a whole lot of patience for the government's intimidation tactics. But there are a lot of Trump appointees on the bench, so it's hard to say.
Well, all we can do is be hopeful. So let's be hopeful. And yes, Chandan says, thank you, John. Thank you so much, Chandan, for your question. I hope you have got your answer. In case you have follow ups, you can post them. Now, John, we were talking about, I mean, you already have advised the viewers to not carry their cell phones, right? Because it has all the information. But let's say if the visa holders, they do carry up their phones or mobile phones, cell phones, to the airport, and then the CBP searches that, then what rights or what I mean, how can they protect themselves during these inspections?
Honestly, the only way they can protect themselves is by not carrying their cell phone or their laptop or their tablets. Because once CBP has the information, there is no control on how they use that information. They can come up with the most crazy and outlandish decisions based on random facts they find in your computer or like electronics. I mean, they go so far as to go through your deleted photos, deleted images, and question why you delete something and whether or not that's indicative of your support for a terrorist group. Just crazy, crazy things. And there's nothing you can counter that with because you don't have any access to the courts. It's just you and some maybe high school educated CBP officer that thinks he knows how the world works, making decisions based on, whether or not you've done something wrong.
Okay. So apart from cell phones, are there other specific items that the visa holder should avoid carrying, to the inspection?
So, yeah, I would say don't carry your computers, your tablets, your cell phones that you normally use.
Okay.
Yeah, like I said, if you need something, take a burner phone, but don't have any of the apps loaded that you normally use. Don't log into the accounts that you normally use. Just strip it down. And you're not required to give them anything, any passwords or anything. You don't have to give that to them at the port of entry. They can search what you've got on you, but that's about it. They can question and ask you for that information, but you don't have to give it. So the things that I would say, especially for the H-1B community, you need to take your petition, your LCA, contacts. If you're working for a staffing company, contacts for both your employer, your staffing company employer, as well as the client, so that if they have questions, they can call and verify your employment with both places. I would say, especially for the client, talk with them before you travel. Make sure you have a point of contact that you have personally spoken with, so that when CBP calls, they're aware of the situation. And prep the client, the client contact, and just say CBP has gotten kind of crazy and aggressive. There's a chance that I could be put into secondary and ask questions. I need a contact that will vouch that I work there when they call, and just let them know that that's what's going to be happening, so they're not terrified when the government calls them.
Okay. And let's say there are some visa holders who don't want to go through the searches, or maybe there are a few visa holders who are refusing about for the searches. I mean, the cell phone searches, or they don't want to unlock their phones basically. So are there like potential consequences for that too?
So if you refuse something at the port of entry, they can remove you,
Oh,
and it comes with a 5-year bar. Now, even if you refuse to unlock your devices, I've I've heard from people there that they just have something they can plug in and crack whatever codes on your phone and get access to the phone anyway. So refusing to give a password is probably not a panacea. It's just a speed bump in their access to the information. But if you do refuse to give passwords to the device, you should just be aware that you'll probably be denied entry to the US. If they allow you to withdraw your application, great, but they will more than likely do a removal, which comes with that 5-year bar.
Okay. All right. Ezekiel is also here, John, and he says, which visa type need to carry a G28?
Before I would have just said the primary non-immigrant visa holder. So like the H-1 or the L-1 or the F-1. But anymore, we're seeing things at the port of entry that kind of defy explanation. We see green card holders being pressured into abandoning their green card and relinquishing the green card at the port of entry. And there's no reason why that should be happening. If the government wants to strip you of your green card, there's a process, and it has to be done in front of an immigration judge. And you're allowed entry into the US if you have a green card, and then they go through that process. But they're threatening people, they're pressuring people into voluntarily giving up their green card and then leaving. And then there's nothing you can do once you voluntarily relinquish the green card. So I would say, as a result of that, it would probably be a good idea for anybody who is not a US citizen to at least talk with an immigration attorney before they travel, just to see if there's anything that they should be concerned about in their situation, or how to handle one of these more abusive interrogation techniques. The other word of caution I would give everybody is that there are two very notorious ports of entry in the United States without a doubt, the worst leadership and the worst officers working there in CBP. And that is Chicago, and that is Atlanta.
Oh.
I don't care if you live in Atlanta. I don't care if you live in Chicago. Find a way to travel anywhere but those two places, because they're incredibly aggressive and abrasive and illegal. It's a rogue, they're completely rogue within a rogue agency. So avoid those two places as if your life depended on it.
Okay. All right. Thank you for answering the question, John. And John, also, I would like to ask you that, let's say if some visa holders feel that, their inspection or their interrogation was overly intrusive. So what rights do they have?
They can document it, and they can write a narrative and prepare a declaration. But immediately, there's not much they can do. But that declaration and that evidence and that testimony can be used later on at a pattern or practice lawsuit where, we challenge what the agency is doing en masse to try and force the courts to order them to stop committing these abuses of law. But again, that's something that takes time, and it takes a significant volume of evidence to show that, yes, this is indeed the pattern and practice that CBP is engaging in. If we just go in with one person's experience, that's not going to satisfy the burden for proving a pattern or practice. We have to go in with a lot of evidence from a lot of different locations to show this is an agency-wide problem, and this is what's happening on the ground.
Okay. And what legal protections are available for, visa holders if the CBP officers are, doing inspections of their social media accounts?
Again, once you're coming through the port of entry, there's not much you have in the way of protection, especially if you voluntarily give them your electronics, or they're searching your electronics. They can go through anything that is on your phone or on your computer.
Mhm.
So they can ask for your social media, and I think the DS-160 now does ask for your social media handles, and they can look at the public facing information for whatever purpose they want, and there's not much you can do there either. When it comes down to it, you really have very few rights and protections at the port of entry. The only thing you can do is just protect yourself by limiting the amount of information that you give them through your electronics or through your verbal statements.
Okay. Okay. Thank you so much for answering the questions, John. Let me quickly now move to the viewer's question. So guys, you can also join us on call. You can give us a call on the number 425-436-6335, and you can dial the access code 988888. Yes, you can ask your questions from John through calls. So you can join us on call. Make sure you dial these numbers. Meanwhile, let me quickly take the viewer's question. Rag was here, and Rag has asked that will a G28 agreement with an attorney save the situation?
It could potentially. If they allow an attorney to speak with them at CBP, then the attorney can highlight areas where they're wrong on the law or the facts don't match the law. Classic example of this is where an H-1B employee has an employer or a prior employer that did something illegal. And the CBP officer is grilling the visa holder about that and said, well, your employer did something fraudulent here, that therefore you're inadmissible for fraud. Once your attorney gets involved, if they allow your attorney to engage, your attorney can explain, well, no, a fraud finding requires the foreign national have made this statement. The employer making a false statement is not attributable to the employee, because the employee doesn't have any access to those documents that are filed with the petition. The employee doesn't have any control over what the employer says in those documents. And the only thing that the law allows you to do is to penalize a foreign national for their own misconduct and their own false statements. Those are the types of situations where an attorney can come in and inject some reasonable thought into the discussion and explain, what the law is, what the purpose of the law is, and why the road CBP is going down just doesn't make any sense. And there are, like I said, there's horrible ports of entry that I would stay away from. There are some that are very reasonable and very decent. And if you're going through one of those and their attorney is able to talk, they can walk the situation back if the officer's reasonable.
Okay. So also, John, are they targeting like a particular visa category, or are they targeting everyone who they want to deport?
Historically, I would say they were really going after the H-1Bs, but now we see a lot of issues with Fs and Bs.
Yeah.
Yeah, we see, European tourists of all things, and Canadian tourists being put into detention. Things that have never happened in my lifetime that were unthinkable are now happening, with CBP. So I think what they're intentionally trying to do is scare everybody out of staying away from the U.S. And that's their goal. Is if they're abrasive enough, if they're brash enough, they'll deter people from wanting to come here, which is a very odd mindset. But that's really the only thing that explains everything that's happening within immigration right now.
Okay. Wow. Thank you again for answering the question, John. Drag, I hope you have got your answer. In case you're looking for more, please continue posting your questions. Let me take Sunita's question quickly. Sunita says, I'm an H-1B visa holder and I'm planning to travel internationally for a work-related trip. What should I expect during my re-entry at CBP, especially if I have a recent change in employment or job title?
So it really depends on what your background is, and can't get into your particular background here, but if you have certain things in your employment or your student visa background that are red flags for USCIS, that will definitely increase your odds of getting selected for secondary inspection. As a general rule, people who didn't have any questionable employment on OPT and work for direct employers like Apple, Google, they tend to have far less scrutiny than people that have worked on OPT or have worked for staffing companies. The staffing companies in particular are USCIS and CBP's, favorite target to go after for whatever reason. And so you're going to draw more scrutiny. But if you're working for that product company, that direct hire, you tend to be a little safer from secondary.
Okay. Okay. Thank you so much for answering the question, John. Sunita, I hope you have got your answer. If you have a follow up, please post it in the comments below. John, I again would like to come to you and ask you that with visa categories, are they also targeting people from certain nationality? Because I think just yesterday or day before, I read in the news that America and Russia are going together to go against China, right? So are they also targeting people from certain nationality?
So I think they've, for a long time, this is Republican and Democrat administrations, have been highly suspicious of anybody coming from China just because of the foreign intelligence threats. I think they, you know, just because of the volume of Chinese and Indians, I think those get the most press. That's the people that have the highest number of interactions and are going to have the most bad stories. But like I said earlier, there you see German tourists, Canadian tourists, yeah, people from Europe having problems, which historically was unthinkable. So I think everybody is probably justifiably concerned about traveling to the U.S. right now.
Okay, so basically you can't predict, right?
Yeah, it's very hard. And honestly, I think you look at everything that the Trump administration does, they try to create an environment of uncertainty because that environment of uncertainty makes people scared. It makes people compliant, and it kind of helps them execute their agenda when people are scared and compliant. And so everything they do is about uncertainty.
Okay. All right. Let me quickly take Ansa's question also, John. She says, "Good morning. I need to return home to Jamaica to get my H-1B stamped. Should I wait to travel?"
So Jamaica.
Mm-hmm.
Yeah, so again, that would depend on the specifics of your background. I'd say you want to reach out to an immigration attorney and schedule a call just to see if there's anything in your background that is a potential red flag. I'm guessing if you're from Jamaica, you're probably a nurse, but nurses, as general rule, don't have a whole lot of problem with CBP or USCIS, but still be worth your time to talk with an immigration attorney to see if there's something else in your background that would be a red flag.
Yeah, so maybe Ansa, you can get in touch with John and his team. The details are scrolling below, and let me also read out his details for you so that you can write it down for yourself. You can give him a call on the number 844 592 7336. I would like to repeat it again, it's 844-592-7336. You can also email your concern on his email ID, which is support@wasden.law, and you can visit his website, which is www.wasden.law. So yes, please get in touch with John and his team. They can definitely help you with your concern and can find out whether you have any red flags or not. And if you have another follow-up, please post it in the comments below. Meanwhile, let me take Naina's question. Naina is also here. She says, as an F-1 student, I'm traveling home for a break, but I'm worried about my I-20 and travel signature expiring. How do I make sure I don't face issues with CBP upon re-entry?
So again, that's another specific question where you probably ought to talk with an immigration attorney to make sure that everything is done on your records to allow your reentry. And getting into the specifics, right now would be tough. We'd have to look at your entire file and your entire history in order to give you the best advice on that.
Okay, but John, what are the most basic red flags that one can have, in the background?
So USCIS has blacklisted certain OPT employers. So if you've had any exposure to one of those blacklisted employers, that's a red flag. We early on in the multiple registration situations for H-1Bs, we saw employees getting red flagged for fraud or misrepresentation based on the multiple registration. We sued on that, and that issue went away. It's starting to come back now, and so that's something to be aware of. If you were an employee who is subject to the multiple registration problem, they may ask you about that. Another issue is if your employer especially your cap H-1B employer, was alleged to have done something wrong in the H-1B program, they'll flag you and ask you questions about that and look for reasons to pin a fraud or misconduct finding on you. So it really kind of runs the gamut. USCIS has done a decent job of retaining records and information and collating all that very well, so that if you hit one of their blacklists or one of their flags, the system pulls it up, flags you, and then CBP takes you to secondary and questions you about it.
Okay. All right. Thank you for answering the question, John. And Naina, thank you so much for your question. I hope you've got your answer. Chandan is actually back, and Chandan says, can an individual file a case against visa rejection at the visa consulate and port of entry denials?
So, as a general rule, no. But there's two things at the consulate to keep in mind. There's a visa refusal, a 221G. That is not a final agency action. So that doesn't come under the consular non-reviewability doctrine, the doctrine that prohibits courts to review challenges to denied visas. So if you have a 221G, you still have a lot of flexibility and things that you can do to work through that process. But if you get a hard visa denial, ordinarily, you're stuck in the water. Now, where that's a little bit different is if the consulate tells you they're denying your visa or refusing your visa based on a DHS fraud finding. If you've never been given notice of that fraud finding or a chance to rebut that fraud finding, then you can then take that information and sue USCIS or DHS and have them remove the fraud finding, which would allow you to go back to the consulate and then reapply and get a visa.
Okay. All right. Thank you so much, Chandan, for your question. Let us know if you got your answer and if you are looking for, any other answer, or maybe if you have any other question. Rag says, thanks for the valuable episode, John and ITS team. Will save this. Thank you so much, Rag, for your lovely comment. Let me quickly take Kunal's question also. Kunal says, travel warning for green card, H-1B, F-1 visa holders don't leave the country unless absolutely needed, but no one is saying for how long. How long, John?
Well, that's a good question. I would say as long as you can stay in the U.S. during the Trump administration, that would probably be great. If things settle down and they get restrained by the courts and they actually follow the courts, then things might loosen up. The other thing to just keep in mind, especially when we're talking about CBP, is CBP was the most excited agency in the federal government to have Trump back, because it's almost as if the moment he got reelected, the CBP officials were working with his transition team to implement policies that Trump wanted, because the second he came in, things changed and became more aggressive than they were before, which tells me that CBP, even under a new administration that's more immigrant friendly, is going to take some time to get corrected. The culture there is just adamantly opposed to immigrants in general. So it'll take a lot of work to weed through the people that are driving that culture within the agency.
Okay. Or should we say, until US gets a new administration?
I think that's probably the safest option.
Yeah. All right. Thank you so much, Kunal, for your question. John, here I would like to read, a case study, and I would like to ask a question based on the case study. There's a software engineer from India, and he was holding H-1B visa, was returning to the US from a business trip, and upon arrival, CBP officers took his phone and laptop for inspection. They demanded his passwords, but he refused, citing, of course, privacy concerns. And he was held for several hours, questioned about his work, social media, and warned that refusal to comply could result in visa revocation. So I would like to also understand that what precautions should H-1B workers take to protect confidential work data before traveling. I mean, you already have told that, they should completely avoid taking their cell phones. But then, are there any other precautions that they should take to mitigate the risks?
Yeah, that's really the only thing you can do is, if you separate yourself from your electronics and send them at different times, you're going to eliminate the prospect of CBP going through your stuff. There's really no other way. They don't really respect trade secrets or trade data. They think that they can protect that. USCIS is the same way. They'll demand, trade secrets and information and petition adjudications, but nobody wants to give that. No one employee is worth, the potential of a government screwing up and releasing that information on maybe Signal by chance. And so no company is going to want to do that. And so you just can't trust how they're going to use that information. So coming through the port of entry, again, if you don't have it with you, they can't search it. And that's the best approach.
Right, right. And also, I would also like to understand that what are the risks of CBP cloning or maybe copying data from a traveler's device?
Would I put it past them? No. I would not put it past them, especially to take screenshots or, copies of files, especially resumes, things like that. I would say that's entirely possible.
Okay. And I mean, can a visa holder also challenge such data extraction in court?
If it happens at the port of entry, it's something that it's almost impossible to get into court and stay in court. So, don't count on the courts to fix things after the fact, but take precautions up front. I always tell people the government can screw up your life in an instant with some stupid decision. It's going to take you a very long time to fix that and a lot of money to fix that. So the precaution up front is going to, prevent you from having to go through all of that trouble.
Okay. And, let's say there are, people from other industries like maybe journalists or researchers or lawyers. So do they have like other set of rules? Because, I mean, if they're carrying their cell phones, they will have, sensitive information or professional sensitive information. So, I mean, can they protect at least that?
So if things are a little bit different in that regard, if you're a U.S. citizen, especially if you're a lawyer or somebody that has a legally recognized right to privacy or confidential communication, you can refuse to give your passwords at that point, and then if they're going to go beyond that, they may have to go to court for a warrant to search it. But that's probably the only exception to the general rule I can think of.
Okay. All right. Ansa is back and she says, thanks for the information you shared, John. Thank you so much, Ansa, for your question. And make sure you get in touch with John for your concern. So I think that's it, John. Do you have any last advice for people who want to travel or,
Yeah,
visa
just
holders? Mhm.
when you go to CBP, just know that if you go to secondary, their mission there is to find or get you to say something that's going to make you removable, get you to sign a document that will make you removable and inadmissible for life. They're not your friends. No matter how hard they try and be chummy with you, they're trying to lull you into a false sense of security. When they switch and they go to the threats, the things that they're threatening to do to you, they really can't do. So don't believe it. The worst thing that's going to happen to you is you're going to be stuck in that confined space for a day or two before they send you home. If you get sent home, you still have options. You still have the ability to, kind of chip away at the government's findings through administrative processes, possibly through court for if they're alleging you committed fraud in your immigration history. But if you sign that document, if you agree to things, if you give them information that they use to make a finding against you, you don't have a whole lot of flexibility at that point, and there's not much you can do. The other thing I would say is If it looks like they're going to remove you, request withdrawal of your application. Don't just let them remove you before you make that request, because that request for withdrawal of application of admission gives you a lot more flexibility down the road as well.
Right. Thank you so much for that amazing advice, John. I think that's much needed, and that is something that especially the visa holders need to hear. So thank you so much again for this insightful and amazing episode. And yes, guys, if you want to get in touch with John, especially Ansa and Kunal. And also Chandan, make sure that you get in touch with John and give him a call on the number 844-592-7336. You can also email him. His email ID is support@wasden.law, and you can visit his website, which is www.wasden.law. So make sure that you get in touch with his and his team related your immigration concerns. Thank you so much, John, for another amazing episode, like I said, and hoping to see you real soon with another topic and another episode.
All right. Good talking with you, and everybody stay safe.
Yeah, you too. Thank you so much for being here. Thank you so much, guys, for your amazing questions. And yes, we have another show coming up. Make sure that you're tuned into that too. And that's it from my side. I'm hoping to see you all very soon. Until then, take care and keep on watching and keep on subscribing to Immigration Talk Show.